All right, the Court of Appeals, Division 1 is now in session.
Please be seated. Good afternoon, counsel. Court now calls case number IC150021, Dobie Matley et al. Counsel, this is time set for oral argument. You both have 20 minutes to present your argument. Counsel, for the petitioner, you can set aside some time for rebuttal. Just let us know how much time you want to set aside. Everything here is being audio and video recorded, so be mindful that these arguments could be uploaded onto YouTube and people can view it. I will advise you we've reviewed the briefs, we've looked at the record, we've conferenced the case, we're very familiar with the issues, so as we go through the argument, keep in mind that we don't need a complete and total review of the case. With that being said, counsel? And you can keep track of your time on that clock that's on the podium.
Okay, thank you, Your Honor. Chris Bisney on behalf of the petitioners, Dobie Matley and Dobie Matley, DBA Truckmasters Plus, and I'm also on behalf of Keat Law Office. Your Honor, may it please the court, at issue in this case is whether Dobie Matley was an employer of the claimant or whether or not the claimant was an independent contractor on the date he was injured. Additionally, if Dobie Matley is found to be an employer, was another entity a joint or dual employer? I'm going to spend most of my time here on the first issue, whether or not Mr. Matley was in fact an employer, and then if there is some additional time, I may briefly touch on the joint employment issue. Within the first issue, there's a very important sub-issue that I spent a lot of time briefing. That's the law of joint venture and how that factors into the analysis in the case at hand. Now, if Dobie Matley and the claimant were engaged in a joint venture at the time the claimant was injured, our position would be that the law of joint venture was confused and not applied correctly in this case. If a joint venture was in fact in operation at the time of the injury, that would potentially resolve certain issues under the right to control test and the other home insurance factors. So, of course, the right to control is specifically one of the 5 elements of a joint venture, and it's also one of the it's one of the elements of the joint venture, and it's one of the factors in the home insurance factors.
But
so,
counsel, let me interrupt on that point, because the ALJ in her decision upon review resolved that issue largely on credibility grounds, finding that your client's testimony about the joint venture was not credible, and that the claimant, Mr. Brown's testimony was. So it's pretty hard for us to reverse a credibility determination on appeal on that point.
That's understood, Your Honor. Our position is that the findings applied the law of joint venture incorrectly. Whether we're not arguing that there wasn't some factual findings that were made, but that they were applied to the law incorrectly. Specifically, if we just go through the elements of a joint venture, that there was a finding that there wasn't an agreement for a joint venture. Now, the law is clear on this. There can be an implied agreement or an express agreement. There can be an oral agreement. There can be an oral agreement with additional implied terms. There's options. It's not, was there an express agreement? There can be other types of agreements that would satisfy that prong under the elements of joint venture. So our position is that even, I can go through the findings one by one and give you our position on that, and that's what I'll go ahead and do right now. I just went over an agreement. The other issue was whether or not there was profit sharing. Now, the ALJ specifically said there was no evidence that the applicant shared in profits or losses. We disagree. In the record, there was testimony that there was sharing of profit and losses. So
Testimony by whom?
that was by Mr. Matley. So
Anybody else?
no. So there is evidence in the record. There's no credibility finding as to whether or not that testimony was credible or not. It was just it was overlooked. There was a conclusion that there was no evidence that there was a sharing of profit and losses. No credibility finding, and there is evidence in the record that is in direct contradiction to that finding. So
If the ALJ found your client not credible, though, then there would be no evidence, right?
well, Judge, the credibility findings were very specific in this case. And I've outlined that in, I believe, our reply brief. There was 3 specific credibility findings. None of them were general. They didn't find him generally not credible. They found him not credible as the specific items. And those items do not include that he shared in, that there was a sharing in profit losses or a failure to share in profit or losses.
Can you direct us to where in the testimony, like page numbers, Mr. Matley testified that he did share profits and losses with Mr. Brown?
Sure. I believe it's identified in my reply brief. I can point you to a specific portion of that.
And what did he say about that? And didn't Mr. Brown deny that he shared in profits and losses?
Mr. Brown did deny that. Mr. Matley, and I will get the page you're looking for, if I could just finish my train of thought. Mr. Matley basically explained it, a partnership in the distributions and items like that would be joint ventures and partnerships. Obviously, are very simple. Not similar, excuse me. There's accounting, there's distributions, there's capital accounts, and he identified that he was receiving distributions. Mr. Brown was receiving a distribution out of the joint venture, and that it was an equal distribution based on the profits that were had from each transaction. And let me.
And it's fine if you want to look before rebuttal and give me
Okay.
the page numbers. I don't need it right now.
I'd prefer to do that to preserve my time. So our position is that all 5 elements of a joint venture were met, and that leads us to how that business relationship would play into the right to control test in determining whether or not he was an independent contractor or an employer. I believe it was the Fry case that they discussed a franchisor-franchisee relationship, and they actually looked at the contract between the parties, the franchise contract, and that played a role in their determination of whether or not that award should be set aside or affirmed. Our position is that a joint venture goes even further. The elements, one of them matches up directly. There's a right to control element and a right to control factor. The element would obviously play a big part in determining how that factor was, the analysis under that factor in the independent contractor analysis. And I know this is kind of confusing.
I'm not sure exactly which aspect or right to control you're referencing. I guess I understand that in a joint venture, both joint venturers would have a right to control the business to a certain extent, but I'm not clear that they have a right to control each other.
Well, Judge, the best way I can explain it is within a joint venture, each party has a right to control the venture.
Yeah.
Now, if you transition that into the right to control in the independent contractor analysis, if each party can do as they please, I guess you could say, how is it that they could be controlled in the independent contractor analysis? And that's exactly what the position we've taken here.
Let me understand the big, kind of zoom out, so to speak, here and understand the big picture. If there was a joint venture between Mr. Matley and Mr. Brown, under workers' comp law, could Mr. Brown be an employee?
Could Mr. Brown be an employee of the joint venture? Is that what you're?
Yes.
Well, the joint venture is a distinct entity. I guess technically, the joint venture could be insured. It could be named as a party, and Mr. Brown would technically be filing a claim against himself.
The finding here is that Mr. Brown is an employee of Mr. Matley and Mr. Matley's business, right?
Yes. And our position is that the two were engaged in a joint venture. And it's a very, the concept, I like comparing it to the Fry case because you have a franchisor franchise. This is a business relationship where I would never imagine there would be a claim going up to the franchisor for workers' compensation from the franchisee. I'm assuming that, that was it was a ways back. So the specifics of how to avoid those type of predicaments have been worked out in the agreements, even the boilerplate agreements that a franchisor gives to a franchisee are going to address that. So
I guess I'm a little confused because if you're arguing for a joint venture in conjunction with arguing that Mr. Matley then necessarily had the right to control Mr. Brown, doesn't that make Mr. Brown more of an employee?
he had a right to control the venture.
Yeah.
As did Mr. Brown. They're co-ventures. No one can control each other. They control the operation, which is moving trucks. And that's another issue.
Let me follow up on what you just said, because I understood what you said about the profit and loss, and you're going to get me that information. Where in the record is there testimony that Mr. Brown also controlled the operation of this entity, this business, this joint venture, as you call it?
It's everywhere. The operation is moving a truck. Mr. Brown has a commercial.
Matley found the trucks. Mr. Matley directed Mr. Brown where to pick up the trucks, where to take them. He paid the expenses. He reimbursed Brown. He got the logs. He paid the expenses. Where is there evidence of Mr. Brown doing reciprocal things on the opposite side in control of the joint venture?
Well, I have a kind of a sub-argument to address that, but I'll go straight at what you asked. He essentially controlled the entire movement of the vehicle. He had the commercial driver's license. He had the knowledge. He had the skill. He was the only one with the ability to actually move that vehicle. How he's not in control of that, it's beyond me. So
it's up to him where to go, where to drive the vehicle, when to drop it off. He didn't need direction from Mr. Matley on any of those points as a co-equal in a joint venture, is your theory?
The location, the pickup location and delivery location were dictated by the purchaser of the vehicle, and that Mr. Matley was not the end purchaser. He was a hybrid broker, I guess you could say. So he didn't dictate where the vehicles went. He just told Mr. Brown where the vehicles needed to be delivered because that's where they were ordered from. He didn't say, "Hey, I need you to, bring this thing,
once it was established where the vehicle is and who's buying it, that establishes where it has to be moved from and to."
Yes. And that's dictated by who is purchasing the vehicle, where they're located. If they're in California, if they're in Montana, Mr. Matley relays that information and says, "Hey, you have the commercial driver's license. I have the ability to find these vehicles. Let's pool our resources, our abilities, and let's get this vehicle to the location." Now, the control aspect in this case, per the ALJ's findings, is that Mr. Matley called him and checked in. How that controls a commercial driver who is in charge of his logbook and who has to make sure he's complying with our requirements, federal. I don't know how phone calls control a person. When they already have a predetermined destination, it's dictated by the buyer where they're located, and calling him and checking in, there's a dispute how many phone calls were made. I don't think it matters. If he's calling him 100 times, how does that affect how he's moving the vehicle? Mr. Matley can't say, "Hey, I want you to exceed your cap on hours they're limited by federal law." He can't do that, and he didn't do that. So there is no control. And I believe and this is kind of the subsection of this, the ALJ defined the venture as buying and selling trucks. That's not the case. Tucson Trucks, another respondent employer in this case, Tucson Trucks actually bought the trucks or provided capital and permits and stuff like that. Mr. Matley didn't buy the trucks. In this specific venture, he was involved in moving the trucks. These are separate, and you can have as many joint ventures as you want. You can have a joint venture to do one thing, a joint venture to do another, and that's what we have laid out in our briefs. There was a lot going on here. It was sort of some uncomplicated people dealing with a very complicated transaction. So moving on, so if we do get to the Fry case, we think that this joint venture relationship goes well beyond the Fry case, the franchisor-franchisee relationship. I mean, that's contractual. There is no elements. There's no factors. It's contractual. And of course, a joint venture is contractual, but in order to actually have one, you have to meet certain elements. And when you do meet the elements, it affects whether or not a person is an independent contractor in a workers' compensation case. And that's exactly what our argument's here. And we don't think the law of joint venture was applied correctly. And because it was not applied correctly, the conclusion in the case was incorrect. And the legal analysis was not correct. The application of the very limited findings that were originally erroneous and based on an application to a non-party who was actually an owner of a business, there's just not enough there. And this is obviously a legal issue.
These are mixed findings of law and fact?
Excuse me, Your Honor? These are mixed?
Mixed findings of law and fact?
The judge made factual findings, obviously, and she applied those facts to the law. And in applying the facts to the law, she did, in our position, she did that incorrectly. She didn't have the full case law. She didn't apply the full spectrum of case law as to how a joint venture could be formed. And she specifically said in her first award that she probably thought the parties intended to go into business together. That alone, I mean, shows that there was something more going on here.
Well, that was as to the new entity that wasn't even in existence and operational on the date of the injury here, wasn't it?
Yes, it was. But at the same time, it does show that the administrative law judge was curious as to these other pieces to the puzzle. And the first factual findings, quite frankly, I don't know how you can make factual findings in application of these factors to a business owner as opposed to it's like saying, hey, Bill Gates didn't do this when it's Microsoft. It's not Bill Gates. You don't apply the factors to Bill Gates. He's an individual. He's an entity. If he goes and operates as a sole proprietor, he's not a corporation. So everything that took place in that first set of findings, it was erroneous. It was based on a misapplication to a non-party. So we move on to what we have in the second set of factual findings, and there we run into problems with the application of the joint venture law. So, there's a lot going on here, and I wish I had more time, and I do want to save a couple minutes for rebuttal. But I guess in conclusion, we'd ask this court to really look closely at the law of joint venture and how these players and these parties in this case interacted. Look at the record, see that there is evidence that there was some profit sharing, find the 5 elements of joint venture were met, and look at the interplay between the existence of a joint venture, the Fry case, and the application of an independent contractor analysis, and ultimately set aside the administrative law judge's award, finding a compensable claim. And I'll go ahead and reserve the remainder of my time for rebuttal.
Do you want to follow up on the next questions of law and fact issue?
No, I believe that'll be yours.
All right. Thank you, counsel.
May it please the court. My name is Todd Lundmark, representing Focus HR and Travelers. It's fair to say that the workers' comp litigation dealt mainly with the relationship between Brown, the claimant, and Matley, the broker. Was Brown an employee of Matley? Our concern is really over the relationship between Brown as a claimant and Focus HR and its client, Tucson Trucks. Let me start by noting, and let me say also that since the main focus of our litigation is on the relationship between Brown and Matley, I'm going to defer most of my time to Ms. Chuan, so I will be brief. But let me start by making a few comments about what Focus HR is. It's a professional employer organization, or PEO. For its clients, like Tucson Trucks, it provides a number of services, including hiring and payroll and workers' comp coverage. But that's not for all employees of a client like Tucson Trucks. It's only for employees that Focus HR leases to the client. There has to be some paperwork that registers the new employee with Focus HR for that relationship to lock in. The record is very, very clear on this point from both Drew Harrison of Tucson Trucks and the claimant himself. None of that was ever done here. This person was never leased by Focus HR to Tucson Trucks, its client.
There's no document suggesting there was ever an employment relationship with Focus HR or Tucson Trucks.
None whatsoever. Now, that should probably end it from the standpoint of my client's point of view. But let me touch on the relationship between Brown, the claimant, and Tucson Trucks very, very briefly. It's a remarkable fact that Brown and Drew Harrison barely knew each other. Brown testified very clearly that Matley hired him, Bradley paid him, Matley directed his activities, Matley gave him the trucks that he drove. He had no relationship with Tucson Trucks. Matley himself emphasized that they were joint ventures, fellow independent contractors, if you will. I never understood him to argue that Brown was an employee directly of Tucson Trucks. And for his part, Drew Harrison testified very, very plainly that his reason for hiring Matley as a broker, and he was one of a number of brokers that he used, but Matley also provided the transportation that made him an attractive broker. He hired the drivers who could transport the trucks.
Go ahead.
Drew Harrison had nothing whatever to do with the drivers that Mr. Matley hired to drive for him. That's as clear as can be on this record. So my point is simple enough. Judge Gaffney concluded that as between Brown and Focus HR and its client, Tucson Trucks, no employment relationship ever developed, and I think that's very, very strongly supported by this record.
If there had been a joint venture between Mr. Matley and Mr. Harrison's business, then perhaps Mr. Brown could be an employee of your clients.
I suppose so, Your Honor, but I've never understood that to be the argument. As I understand the joint venture argument, it says between Matley and Brown. I've never understood them to be arguing that somehow Tucson Trucks was a joint venture with Matley.
There was the discussion about Phoenix Trucks, and when it became operational, maybe there was something in the offing about that.
Yeah, and some of the record I found to be pretty confusing, but I'm with you on this. Phoenix Trucks isn't part of this because it wasn't really in existence on the date of this injury. So, unless you'd have more questions for me, I'd like to reserve the rest of our time for Ms. Chua.
Thank you, counsel.
Thank you.
May it please the court. My name is Brianna Chua with Taylor & Associates, and I represent respondent employee Mr. Torrey Brown. I think the overarching thing that we would like to leave this court with is to remember that the evidence has to be considered in the light most favorable to sustaining the award. Dobie Matley was found to be the employer by Judge Gaffney, and I think credibility is the first thing to look at. When an ALJ makes findings of credibility, they cannot be ignored, and they are generally binding on a reviewing court. Matley, in his reply, is saying, well, hey, she only found 3 findings of credibility specific to certain points. Well, that may be. However, the fact that she made findings of credibility cannot be ignored, and I think is indicative of how she saw the witnesses as the trier of fact. And I don't think that if she went through the trouble of finding Matley not credible, that we should then presume that she would have found him credible everywhere else. It doesn't make sense. And it's not, as far as I know, I'm unaware of any case law that requires her to make findings of credibility after every single statement of and every single finding.
Excuse me for interrupting, but
Yes.
before I forget to ask and we run out of time, what about the argument that there's really no indicia of control here, and the finding that Mr. Brown called in a number of times doesn't really mean anything?
Mr. Matley called in?
I was thinking it was Mr. Brown, the driver, who called to Mr. Matley several times.
No, actually, if the record shows that Mr. Matley would call Mr. Brown and also
Okay.
Mr. Macklin as well, who was the other driver. I think it was 10 to 15 times during the day to find out where they were, tell them to hurry up, when they were going to arrive, and that sort of thing.
So your argument is then that Mr. Matley called Mr. Brown as part of his control of Mr. Brown as his employer.
Absolutely. Mr. Matley had all the control in this case.
What if it was the other way around and the record showed that Mr. Brown was calling Mr. Matley for unspecified reasons?
Well, hypothetically, because the record doesn't show that,
All right.
if Mr. Brown had to call Mr. Matley, it kind of goes the same way. If Mr. Brown's calling Mr. Matley to say, hey, I need money for fuel, I need money for lodging, I need the paperwork to get across state lines. What do I do because now my air conditioner broke? And actually, those things the record reflects did happen. It shows that Brown is then asking Matley for permission, for resources, for direction, and the testimony shows that it was actually Matley that had all of that control direction.
And I'm looking at ALJ's number 7 finding now, and it actually says, it doesn't say which way the calls were. It says the right to control is evidenced by the fact that Matley kept in touch with the applicant several times per day.
Right, yeah. And to be fair, I think probably phone calls did go back and forth. There was testimony about breaking down and not knowing what to do, about a deal not going through the way that they anticipated, and a route had to be changed. And in those cases, I suspect if you're breaking down, the call would be made by the driver. So either way, though, given the nature of the calls, it still shows that Matley had the control in this matter.
Switching to the joint venture issue,
Yeah.
tell me your recollection of the record in terms of whether Mr. Brown shared in profits and losses with Mr. Matley.
Well, I'm glad you mentioned that, Your Honor. In the reply brief on page 4, there's a citation, I believe it's to page 112 in the December transcript. And if you turn to that page, it does not, I don't know if it was a misprint or whatever, but
The reason I asked Mr. Bistany to look for that before
Right.
rebuttal, because I did look at that and I didn't see it.
right. I did that too, and I tried in every way to construe it the way they would, and I couldn't find that there was any reference. My recollection of the record is that the only one who talked about profits and losses was actually Matley, and I would like to address the profits and losses. Just if you think about profits and losses in a business, specifically in this case, Mr. Matley testified that he would charge a different amount for the transportation costs in each negotiation, that they weren't always the same. They were not moving the exact same number of trucks each week. They were not moving the exact same type of truck each week. And so if you look at the way that payment was provided to Brown and Macklin, for that matter, as a weekly salary, which was always the same, with the exception of the one increase that Brown had, it didn't vary based upon how many trucks they moved, the type of truck they moved, the amount that was negotiated. Brown didn't even know how much was negotiated for the transportation. That's not sharing in profits and losses. He was getting a salary. The one time that he wasn't getting the 23-day gap where Brown testified that he must not have been getting any trucks that week, that's no different from an employee not being paid for not working that day. That doesn't mean that suddenly he's an independent contractor of some kind or sharing in the profits and losses. And also, Matley admitted that there's no money in transportation. The money is in the sale. And Matley's the one who controlled the negotiation. He had all the knowledge. This is a guy that had a business in Iowa previously. He dissolved that business. He's holding himself out now as truck masters. And he's going to go into business with this little guy that has no knowledge of the business. All he has is the ability to move these trucks back and forth. Matley wanted to include transportation in his deals because it made his clients happy. Mr. Harrison liked that. That's why he used Matley. He got it was something that the client would not have to worry about. He would make sure it got done. And even Matley said he included the transportation because that way he knew he would ensure that the job got done and it would be done faster, allowing him to move on to the next project more quickly and, in short, giving him more money.
Did the record also reflect, as I recall, that Tucson Trucks, which was a major client, issued 1099 solely to Matley, not to some entity or joint venture or conglomerate of individuals? Is that what the record established?
Yes, the record did say that, and I believe Mr. Harrison could not remember whether the 1099 was issued in the name of Mr. Matley personally or his DBA.
But Mr. Matley did not take out withholding in his payment to Mr. Brown.
True, and that's true, but that's not conclusive. That I don't think that overrides any of the other factors that are overwhelmingly in favor of Brown being an employee.
Let me, as long as I have you here for a moment, please. Finding number 9 on the decision upon hearing strikes me or grabs my attention. The evidence shows that Matley and the applicant probably intended to become partners with Drew Harrison in a new limited liability corporation called Phoenix Trucks and Trailer Sales LLC, but it wasn't licensed and up and running yet. But there must have been evidence to, one would presume, there was evidence to support the ALJ's conclusion or finding, I should say, in that regard. And if so, there must have been some evidence to support that these people, Mr. Harrison and Mr. Matley and Mr. Brown, were all talking about going into business together or being in business together. I mean, that seems out of sync with the "I'm a mere employee" ultimate conclusion.
No, I don't think so. Perhaps I think the fact that there were separate entities has to be recognized. Mr. Brown had business cards made for him under the Phoenix Trucks name, but not under Truck Masters or Tucson Trucks. So I would disagree.
It seems inconsistent with many of the rest of the findings, somewhat to me.
Well, because I think it was
relevant.
Well, I don't think it's relevant if the Phoenix Trucks was not an entity, and it's not going to be considered in that sense. But I would like to make a point. Mr. Bissany talks about this franchisee. In terms of the independent contractor argument, there was no written contract. And I think that's the first thing you have to recognize. There's nothing in writing. So there was no written independent contractor agreement, no written contract for purposes of joint venture. And so I think that argument would fail. And as to joint venture, I think the judge got it right overall, but she got it right also, saying that there were 3 elements missing, and without all 5 of them, it fails.
If there was a joint venture between Mr. Brown and Mr. Matley, could Mr. Brown still be an employee? Or is that just a stupid question? You feel free to let me know.
It is not a stupid question, Your Honor.
Thank you.
I actually didn't think of that, and so it was interesting when you raised that. I suppose, yeah, I think Mr. Brown could be an employee of a joint venture. I don't think there was a joint venture. Whether you're missing 1, 2, or 3 of the factors, either way, it's going to fail. But I think that he could be. And as to the argument that it was the deal that controlled where Mr. Brown needed to be and not Mr. Matley, just because I have my assistant file a letter because the case dictates the time that letter needs to go out doesn't mean that she's not my employee. So.
Let's say we see no reversible error in the ALJ's determination that there was no joint venture, but we look at this and we say, on these facts, this just looks like an independent contractor.
Well, I would hope that you would not do that. And I think that if you look at the totality of the facts and the fact that Mr. Matley chose to include transportation as a value to him as part of his business, and saying that the person providing transportation it would be basically trying to contract out the very heart of his business, which law says you cannot do. In addition, I think the control factors, which we've already discussed, would lean in favor of an employer-employee relationship, and certainly not in favor of an independent contractor relationship. So, and I would also just point out, I think there is some of these, the facts they are kind of confusing, trying to put them in these holes of independent contractor or joint venture. And I think the reason is because they're mutually exclusive. Either you're together or you're apart. It just, the arguments, they don't really make sense. I mean, they can't really go together. So I have a few minutes left. I don't know if you have any more questions. If you don't.
No.
Okay. Then I would just leave you again with the way I started, and I think the evidence needs to be considered in the light most favorable to sustaining the award. The administrative law judge, she certainly considered all of the evidence, and I think she got it right. The evidence and the facts more than reasonably support her conclusions and her award, and we ask that you affirm her decision.
Thank you, counsel.
Thanks. Thank you.
Rebuttal. Judge Gilmore, do you need more sticky pads? Do you need your bailiff to bring you a few more?
No, I haven't used up this one yet.
And to get back to Judge Downey's inquiry, there was an error on the reply brief. It's actually cited correctly in the opening brief, and that's to page 84 and 85 of the December 2014 transcript, and that's W. Matley's testimony on profit.
Sorry, what pages again?
84 and 85. His testimony on profit and losses. And then additionally, after taking a quick look, looks like there was also, our position would be there's also further evidence in the record of profit sharing shown by Tory Brown's testimony that his pay increased when the co-venture and the three-man venture bowed out. So, and that would be on page 113 of the October 14, 2014 transcript.
His pay increased when Macklin left?
Yes. So, and just to touch on a couple other items before my time runs out here, the credibility findings, limited credibility findings being okay, there not being any case law. I didn't see any case law on that myself. I don't think there's a case on point, but the credibility findings need to be sufficient to support the conclusions. And 3 limited credibility findings that have nothing to do with the legal issues that we're discussing here, I don't think are they're not enough of a finding in order to support anything. They're very specific. You can very easily make a general credibility finding and plug that into every fact that's being in play in the case. So, and I thought that was important to kind of reiterate. As far as there not being any money in transportation aspect of this, there's a buying and selling trucks, and then there's the moving the trucks. If there's more money in buying and selling than transportation, that doesn't mean you don't try to make money doing both. If there's a profit to be made, people are going to go into business and they're going to try to earn a profit. They're going to try to make money. But just because one venture makes less than the other venture, if you're going to earn a profit, it's profitable to do both ventures. So why would you not do that?
It's part of the expense. If you reduce it, you make more money.
Exactly. So any businessman is going to participate in as many business opportunities as they can, and if they're somehow intertwined, that's fine. It takes a lot of time to sort it out, but that's what we're here for. And lastly, a franchisor-franchisee agreement, that can't be oral, it can't be implied. This is completely different than the joint venture agreement, so we would disagree with the position that somehow that is applicable to what we're arguing here, that the franchisor-franchisee agreement, the argument that Brianna made earlier. So with that, I appreciate the time. Thank you for having us.
Thank you, counsel. To all counsel, we will issue a written decision in due course. The court's in recess.
I wasn't ready.
Relax.